which is self-acquired to either the father or the mother. Now, if a male Hindu dies, there are two ways in which his property comes to his legal heirs. The first way is where he leaves a will, and where he leaves a will, there the will be supreme. Whatever he says in the will, if he doesn't want to leave it to any of his children, he wants to leave it outside of his family, he can do so. There is only one exception, and that originally was not created by any act. It was created by the Supreme Court, which held that no male Hindu could leave a will in which he did not give his wife at least that much share as she would get from the normal succession laws, the normal Hindu Succession Act laws. Now the wife has to be given 1/3, that is mandatory. If he wants to make a will, he can make a will as to the balance amount. The Hindu undivided family, the man's share in the Hindu undivided family earlier used to be divided only between his sons and his wife. Now it will be divided among his wife as well as his sons and his daughters. The only person who doesn't get a share in the Hindu undivided family is the mother of the deceased. If she is alive, then she gets a share in his self-acquired property, but not in the undivided family property. If a man dies without leaving a will, then his sons, his daughters, his wife and his mother all get an equal share in that property. It's divided equally. There is one other provision which has been introduced into the Act, which is that if a man dies leaving only 5,000 rupees, then that entire amount will belong to his widow. That's as far as the Hindu Succession Act goes. I am now going to take up Muslim law. Under Muslim law, you are not allowed, no person is allowed to will more than 1/3 of their property. So 2/3 has to go as per the Shariat, the law of the Muslims. They have to go as per that law, and 1/3 of the property he can or she can will away to anybody whomsoever they may desire to. The property that goes according to the law, that is, it can't be willed away. The daughter gets one share as compared to a son who gets double of her share. 2 shares for every 1 share the daughter gets. The wife also gets the same share as the daughter, but there is a share for the mother also, who also gets the same as the wife and the daughters. So that is to say that if a man has 1 son, 2 daughters, 1 wife and a mother at the time when he dies, then his mother, his wife, his 2 daughters and his 1 son will constitute 6 shares, out of which the son will get 2 shares and all the rest of the 4 women will get 1 share each. Christians go as per the Indian Succession Act, and as far as the Indian Succession Act is concerned, Christians again have the right to will away all their property to anybody whomsoever they may wish to do so. If they do not leave behind a will, then the property of a Christian will go to their wife and their children. I am going to only talk about this law of succession up to this point, because there is more there are more heirs, there are the children of grandchildren and so on and so forth, but they only come into play if what we call a class 1 heir. These heirs whom I have mentioned are not part of the they don't exist. I mean, if we don't have any class 1 heirs, for example, if a man did not marry, or if he married, his wife passed away before him and he has no surviving children, then his grandchildren would stand to inherit. If in any one of the categories any one child has passed away, leaving behind some children, then those children will inherit the share of the child who has passed away. Any other clarifications I would be glad to answer in the open session that is going to now follow. Thank you.
Thank you, Roma, enlightening us on the property and inheritance laws for the women on a different customers law. So, may
special provision for disabled persons?
Actually, there is not. And our experience is that we've had a lot of, I personally have met with a lot of disabled people who have complaints on this issue, and they say that their parents will make a will specifically to disinherit them. And in my opinion, I think that's one of the things we must look for in the amendments to the Act, that a disabled person's share in the inheritance cannot be willed away, just like a wife's share in the inheritance cannot be willed away.
Yeah. Yeah. Now we have the, thank you, Roma. Yeah, end of.
No, Deepika will take them now. We'll take these questions now. We'll take each session. We'll have an open house and we can take the sessions. Yeah.
Yeah. Okay, Mutama.
Yeah.
Well, whatever questions you have.
Yeah.
Yeah.
Actually, the concept of guardianship that has come under the National Trust Act is not really a new concept. We already have an act in existence called the Guardians and Wards Act. It's meant for people who